Hi, my name is Nadav Ravid. I am the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country in connection with their commercial real estate leases. Every month, our firm issues a monthly dirt report newsletter, which covers various new laws, court decisions, and other important information that impacts the real estate leasing industry. This month, we wrote about a recent case, a bankruptcy court case out of Illinois, which answered for the first time that we're aware of the million-dollar question, which is on everyone's mind today, of whether or not rent is due during this COVID-19 crisis. At least it answered it in part. The holding of the case came as a surprise to some people, certainly on the landlord side, because it basically held that a tenant was not required to pay full rent. Most of the rent was not due during the time that the government issued a shutdown, the stay-at-home orders, and prevented businesses from operating fully. Now, it was a bankruptcy court decision. It did analyze Illinois state law, but the reasoning behind the court decision does seem to be applicable to other courts throughout the country and other states. And it will be important and interesting to watch whether or not other courts follow that same reasoning. But having said all of that, it is not a complete victory for tenants, and for four reasons. The first reason is that the court did hold that some rent was due. So it wasn't a complete waiver of all rent during the shutdown period. The second reason why it's not a complete victory is that the court analyzed in this lease had a force majeure clause that I would describe as atypical. It's not completely unusual, but it's certainly in the minority of the types of language that we see out there in your typical force majeure clause, and we'll get into that in a second. The third reason that it's not a complete victory is that not was excused, only a portion of the rent was excused. So, and again, we'll talk about that in a second. And then the last part that renders this decision somewhat favorable to a landlord is it did hold that the doctrine of impossibility was not applicable, in that the force majeure clause superseded the doctrine of impossibility. When there are a lot of retailers out there that are stuck with bad force majeure clauses, and they are arguing that the doctrine of impossibility would trump the force majeure clause. Well, in this court, the judge ruled that the force majeure clause superseded the doctrine of impossibility, which again could be good news to some landlords. So what are the facts of this case? Again, somewhat interesting, very favorable to the tenants. In February of 2020, and that's very important, it's before the pandemic, the official pandemic shutdown orders took place. So in February of 2020, a restaurant in Illinois filed for bankruptcy protection. They went out of business, they closed. Actually, I think this particular restaurant never even opened. But they stopped paying rent. And in March 16th is the date that Governor Pritzker of Illinois actually issued their the state order that required everyone to stay at home. And that order specifically ruled that all on-premises consumption of food and beverage was prohibited. But importantly, that order did not preclude, and in fact, it encouraged restaurants to continue to provide takeout and delivery. So again, it wasn't a complete shutdown for the restaurant business. Now, it'd be interesting, again, we'll talk about other businesses that had a complete shutdown, like, for example, apparel businesses. The last bit of factual information that's relevant is what the lease force majeure clause said. And I'm going to read this to you. And again, you could read this in our monthly dirt report that's coming out tomorrow. The monthly dirt report, excuse me, the lease force majeure clause provided as follows. Landlord and tenant shall each be excused from performing its obligations or undertakings provided in this lease in the event but only so long as the performance of any of its obligations are prevented or delayed, retarded, or hindered by laws, government action, emphasize government action or inaction, orders of government, emphasize orders of government, and then it gets into the final sentence, which says, lack of money shall not be ground for force majeure. So in essence, what it said was, if there is a government order or some type of government action that takes place, the parties are excused from their obligation to perform, but lack of money will not be a basis to claim that you are not required to perform. So that's different if you recognize other force majeure clauses. A lot of force majeure clauses, I would say the majority, will actually say, instead of saying lack of money will excuse performance, they say, notwithstanding all of these lists of types of events that could excuse a party's obligation to perform, like a government action or a hurricane or an earthquake or other types of events, a riot, etc. Even if all of those events occurred, a lot of force majeure clauses will say that notwithstanding those events, a tenant's obligation to pay rent is never excused. Here, this force majeure clause did not say that. It just said lack of money would not be grounds for force majeure, and the tenant cannot use that as a basis to excuse performance. And so based on all of those facts and circumstances, the landlord argued that the tenant's rent was due for 3 reasons. First, the landlord argued, and these are common arguments that you hear landlords making across the country. First, the landlord argued that the tenant was never prevented from actually continuing to pay their rent. The banking systems were still working. The tenant could have sent a wire. The tenant could have written a check. They were not prevented from paying rent. So they cannot say that, hey, force majeure prevented me from making the performance of paying rent. And the court was very tough on the landlord on this, and it actually described the landlord's position as a specious argument, which is a pretty big slap on the wrist on the landlord's argument, saying, look, that is completely without any basis. They're not even going to consider that as a viable defense by a landlord, and they basically rejected it outright. So they said, look, that's not what was intended to protect a tenant from a force majeure. Just the fact that they could write a check or send a wire is not really what we're talking about here. The second argument that the landlord made was more directly on point, which is say, look, the force majeure clause said lack of money is not going to be a defense for the tenant. The inability to have money should not be the basis for claiming force majeure. But again, here the court, this is really the crux of the decision. The court said, look, lack of money was not the basis for the tenant to claim that rent was not due. It was really the government order that prevented the shutdown. That was the proximate cause that justified the tenant's position that, hey, it was the government order that was the reason why I wasn't able to operate and therefore should not be required to pay rent. And the court agreed with the tenant on this argument. So it rejected this lack of money. Now, again, things probably maybe would have been different if the force majeure clause was written in a way to argue, to say that even if all of these events occurred, government action, an order, even if a force majeure clause said pandemic, whatever, if it said that notwithstanding all of these events, the tenant's obligation to pay rent is never excused, it would be interesting to see the court might have reached a different conclusion here. But that's not what the force majeure clause said. It just said that lack of money would be an excuse. It would not serve as an excuse to justify lack of performance here, in this case, paying rent. So here the court said, no, it wasn't that it was lack of money. It was that the reason for the tenant's failure to perform, which justifies failure to pay rent, was because of a government order. Lastly, the landlord threw in the kitchen sink and said, hey, the tenant did not apply for the SBA loan, the PPP money, and therefore they are not entitled to claim that they don't owe the rent. But the court rejected that argument and said, look, there was nothing in the lease that required the tenant to apply for the government money. This is a very important decision. The tenant has won the first round of these court decisions in this case. And again, but keep in mind why it's not a complete victory. The court only held that the rent, again, we'll talk about the partial rent in a second, wasn't due during the time of the shutdown. Once the shutdown is lifted, then it's no longer the government action that would justify a failure to pay rent. So once the government order is lifted, again, by this court's logic, then the tenant would owe 100% of rent. But going back to the time period of when the government shutdown was in place, the court actually held that not all of the rent was excused, because since the tenant had the right to have, and the tenant had the right to continue to do delivery, some of the space was usable. And they used some language that the tenant explained that, hey, the dining area comprised of about 75% of the premises, and the kitchen was only about 25%. Again, I'm paraphrasing some of it. The court held that at least that portion that was usable, the 25%, should be payable by the tenant. So the tenant was required to pay 25% of the rent. So again, it's not a complete victory. They had to pay 25% of the rent. And also that reduction of the rent only applied during the time of the government shutdown. This was an Illinois bankruptcy case. So some unique differences from your typical landlord-tenant lawsuit that goes in the state court. Some other factors that are sometimes in play. It'll be interesting to see how other courts, whether or not other courts are persuaded by this decision, or there's still more to come, although it does seem, from what we're hearing out there, other than just from this one particular case, but I've been hearing about some other cases, that early rounds are going in favor of the tenants, supporting their position that certainly not all of the rent is due. Stay tuned for more decisions. I'm sure we'll get more, and we'll follow up next month. Thank you.